Please be seated.
Criminal offense number 132 of 2026, Uganda versus Miria Matembe.
By the time I finished, I realized there's no power, so I'll just sign a soft copy.
Akyali Stephen for the applicant. Our bar for the applicant in terms of representation is as before. And the people in the state is in court. The matter is for ruling, we are ready to receive the same.
Just a ruling of 13 pages. So the applicant, described as Dr. Miria Matembe, through her counsel, made this oral application for the grant to her of bail under the Constitution of the Republic of Uganda as amended, Magistrates Courts Act, and the bail guidelines. The background: this is an application for bail pending trial. On 30th June 2026, the applicant was charged with the offense of promoting sectarianism in this court, contrary to section 38(1)(d) of the Penal Code Act, chapter 128, and remanded in custody till the next day when this bail application would be made. Today is the day. For the representation, the applicant was represented by counsel Akyali Stephen, together with Kato Tusime, Muhoozi Samuel, Lillian Drabo, Anthony Asimwe, and Nyangoma Patricia, while the state was represented by the senior state attorney, Ms. Kulsum Mariam, from the Office of the Director of Public Prosecutions. The application. The grounds of the application as stated by counsel for the applicant or accused were twofold. The first was for bail upon her own recognizance, which was majorly motivated by her advanced age and the ultimate desire to avoid injury to sureties. The second was bail with sureties, which was stated to be in the alternative. The first angle was premised on Article 23(6)(a), Section 11(2), and Section 23(6)(a) of the Constitution. You will bear with me because I've done this so fast. I'll just add in small things of the Constitution. Section 11(2) and Section 75(1) of the MCA, that is the Magistrates Court Act, whenever I say MCA. In those provisions, counsel argued that the accused person can be granted bail on her own recognizance upon consideration of the fact that the applicant is of advanced age, being a 73-year-old, and her stature as a responsible and respectable citizen of Uganda, who is a former Minister of Ethics and Integrity in the Uganda government, and has held various respectable and noble offices of great importance in this country, including participating in the promulgation of the current Constitution of Uganda as a member of the Constituent Assembly. The others are that the applicant has a permanent residence at Lake Drive Zone, Luzira Parish, Nakawa Division East in Kampala District, within the jurisdiction of this Honorable Court, with a strong community ties and low flight risk. Second, the applicant is not a threat to, I imagine some of the ground. The applicant is not a threat to any prosecution process and is willing to appear before this court for trial or mention as and when required. And three, her antecedents demonstrate her respect for the law and compliance with any bail conditions given. According to counsel, she had no record and has lived an exemplary life. Counsel submitted that the charge sheet was clear evidence of age, and the raiding of the house of the applicant was also additional evidence of her residence. Counsel cited the case of Dr. Alex Kamugisha versus Uganda, High Court Miscellaneous Cause number 94 2007, for the proposition that 50 years and above constitutes advanced age. Counsel also described as a preliminary the process of raiding and arrest of the accused person to submit that the matter in court now is political, just as the charge now before court. To counsel, this spoke to the nature of the offense in court. To him, denying bail would beget a chilling effect on fundamental rights in the Constitution. Regarding the nature of the offense, counsel submitted that the court had itself admitted that the offense was not so grave, and also there was no risk to interference with witnesses. Counsel also referred to the jurisprudence, both domestic and comparative, that favor the grant of such bail. He referred to cases like Foundation for Human Rights Initiative versus Attorney General, Constitutional Petition number 20 of 2006, and Colonel Dr. Kiza Besigye versus Uganda, Criminal Application number 83 of 2016. The alternate ground was that the applicant had substantial sureties who are willing to ensure compliance with the bail conditions once the applicant is released on bail. Briefly, the sureties that have been presented are: 1. Honorable Lucy Akyali, a member of Parliament, a friend to the accused and an associate of the accused person in the Uganda Women's Movement. 2. Honorable Kabasharira Naomi, an aunt to the accused person and MP for Rushenyi County in Tungamo District. 3. Miss Prima Kwagala, an advocate of the High Court of Uganda and the subordinate courts there too, well acquainted with the duty of a surety, and she was an associate of the UNET. Lastly was Mr. Godbert Mushabe, a lawyer and executive director of Great Lakes Institute of Strategic Studies located in Nigeria B, and an associate lecturer at the Makerere University School of Law. The residence, contacts, and profession of these sureties were outlined, and original documentation showing their identity and residence tendered into court. In conclusion, counsel submitted that no exceptional circumstance was required in this court in this bail application. That it is only fair and just that the court take into account the health of the applicant and the obligation to do justice under Article 126(1) of the Constitution, and that the obligation to do justice under Article 126(1) of the Constitution would require that the applicant is admitted to bail and released accordingly. In reply, the prosecution opposed the bail application on the following grounds. First, it was their submission that the accused person had not provided her national ID or passport to the court as required in paragraph 12 and 13 of the bail guidelines. It was her fear that the accused could flee the country or the territorial jurisdiction of the court. As regards the argument that the accused is of advanced age, the prosecution argued that the fact of being advanced age did not entitle one to mandatory bail from the court. Bail remained at the discretion of the court. Third, the information of what transpired about the raid by state agents was, in short, evidence from the bar, and there was no iota of evidence to prove the same. Rather, the prosecution argued that the very fact of raiding would mean that the accused is a fugitive on the run with no fixed place of abode since she is in hiding. Fifth, as regards the sureties, the prosecution argued that the fact that the accused person did not know the surety's residence contradicted the fact that they were her friends well known to her and able to compel her to come to court, or for the state to trace the sureties should the accused person abscond. Sixth, to her, some of the sureties had not been truthful by giving wrong phone numbers, such as surety 1, Honorable Lucy Akyali, and surety 4, Godbert Mushabe. She also expressed fear that the duty station in terms of the constituency of surety 1, Honorable Lucy Akyali, in Amuru is too far for the surety to monitor and compel the accused person to attend court. Lastly, as regards the medical report police form 24, which I will refer to as PF 24, she submitted that the form had been disowned by the accused, who had denied being examined upon it. She found it unbelievable that the same counsel for the applicant would rely upon the same as proof of ill health. To her, such ill health had not been proved and, in short, should be disregarded as a factor in the consideration of the bail application. In conclusion, she attacked the character of the accused person in court, who seemed uncourteous and rude in answering questions put to her by state prosecutor during her reply, in her attempt to determine the substantiality of the sureties. She also argued that these answers show that the accused person is likely to continue with saying such words that are already complained of in the current criminal matter. All in all, she prayed that the bail be denied. Rejoinder. In rejoinder, counsel for the applicant tackled the issues raised in reply by the prosecution. First, counsel argued that the state had skipped paragraph 13, A and E of the bail guidelines, which provide for the consideration of the gravity of the offense and the applicant's age and physical condition. As regards the ID and passport, counsel noted that failure to tender this in was an oversight, and tendered in the ID and showed court the original passport. As regards reliance upon police form PF 24, counsel argued that the prosecution was bound by Section 15 of the Evidence Act on the application of the parole evidence rule, which excludes documentary evidence in the presence of a written document. Upon perusal of that act, I found that the section was wrongly cited. The correct sections run from sections 91 to 100 of that act. Nevertheless, the argument holds, albeit that the wrong law was cited, and will be considered in the evaluation of the application. As regards the character of the accused, counsel referred to the BCJ case to state some principles. These are that the accused should not be unreasonably deprived of bail as a punishment, as it impairs the presumption of innocence. Further, argue that such denials should be based not on mere allegations. Counsel also submitted that the variance in the name reflected in comparison with the phone numbers provided by sureties 1 and 4 was due to one error in transcription of the numbers of these sureties. The first was an error of the prosecution, and the second by counsel for the applicant. The correct numbers were provided. In conclusion, counsel argued that the factors to be considered for bail are in paragraph 15 of the guidelines, and the substitutions of the state are not included therein. All these arise from the Article 23 of the Constitution, which he called the Grand Norm, which utilized the word may, implying the use of discretion of the court. To counsel, this gives the court a wide discretion which should be judicially exercised. Counsel also reiterated that the accused has a fixed place of abode and is a married woman who has no intention of abandoning her fixed place of abode on Lake Drive, Luzira Parish. He reiterated the earlier prayers for this court to allow the application. Consideration and determination of this application. I've carefully considered the submissions by both sides, Land Council for the applicant and Land Council for the state, which I will not reiterate. I have also read and analyzed the cases quoted and the law as a whole, albeit that the time was relatively short. I was, however, able to appreciate the vital elements in the arguments of the two parties, and I am grateful for their preparation and spirited arguments presented to court today. These enable the court to arrive at a decision that is supported by the law and the evidence. The nature of bail. The decisions cited were clear on bail provisions. I will only summarize their content. Originally, bail means security given to court by another person that the accused will attend trial on the day appointed. This is the alternative argument of accused counsel. It also includes recognizance entered into by the accused themselves, conditioning them to appear, and failure of which may lead to a warrant of arrest and confinement in prison till the trial of the case is heard and finalized. This reflects the primary argument for bail by the accused person. However, in both these instances, bail may also lead to forfeiture of the recognizance by the accused or applicant and even the sureties, whereby they are ordered to deposit the money they were bound to court. Bail is granted to an accused person to ensure that he appears to stand trial without necessity of his being detained in custody in the meantime. The effect of bail is merely to release the accused from physical custody, as has been held in the cases cited, but he is still under the jurisdiction of the law and is bound to appear at the appointed time and place. What is the basis of bail? Indeed, as a long recognized principle under the criminal law, bail is premised on the presumption of innocence in Article 28(3)(a) of the Constitution, and the case law under that needs no restatement in terms of precedence, as it has been subject to numerous applications in the courts of record. It's also premised on Article 23(1)(a) and 23(6)(a) of the Constitution, which grant court the right to grant bail in its discretion with conditions it considers necessary. In the observance of the personal liberty of its citizens. In the magistrates' courts, bail is additionally governed by the provisions of Section 75 and 77 of the Magistrates' Courts Act, Chapter 19. This application is made under Section 75 of the MCA, where it is provided that, and I quote, a magistrate's court before which an accused person appears or is brought charged with any offense may, at any stage of the proceedings, release the person on bail on taking from him or her a recognizance consisting of a bond with or without sureties for such an amount as is reasonable in the circumstances of the case, to appear before the court on such a date and a time as is named in the bond. I've underlined may at any stage of the proceedings. So it is discretionary and at any stage. The discretionary nature of bail. Whereas Article 23(6)(a) of the Constitution and Section 75 of the MCA allow the applicant to apply for bail, the grant of that bail is not automatic. For that, you see the case of Foundation for Human Rights Initiative versus Attorney General, Constitutional Petition number 20 of 2006, that counsel for the applicant provided. All the provisions of the law I have quoted use the expression may, which means that court is given or left with discretion to grant or refuse bail. Indeed, as has been noted, it must always be borne in mind that where any legislation confers upon court discretion to do anything or grant a relief, such discretion has to be exercised without any malice, without any ill will, ulterior motives, or regard to external influence or circumstances. Court must be satisfied that the provision of the law has been complied with. For that, we refer to the case, to the judgment of, the ruling of Masal Musene, the judge as he then was in the case of Colonel Retired Kiza Besigye versus Uganda, criminal application number 83 of 2016. The other details can be read arising from another case. The exercise of discretion in the grant of bail essentially entails the consideration of the conditions set out in the law that court must consider whether or not to grant bail. So Article 23(6)(a) of the Constitution provides, where a person is arrested in respect of a criminal offense, A, that person is entitled to apply to court to be released on bail, and the court may grant that person bail on such conditions as the court considers reasonable. My emphasis on such conditions as the court considers reasonable. Section 77 of the MCA also provides for the discretionary powers of the court whether or not to grant bail to the accused person. In doing so, the considerations to be taken into account by the court include 1, the nature of the accusation, 2, the gravity of the offense charged and severity of the punishment, 3, antecedents of the applicant so far as they are known, 4, whether the applicant has a fixed place of abode within the area of the court's jurisdiction, 5, and whether the applicant is likely to interfere with any of the witnesses for the prosecution or the evidence to be tendered in support of the charge. I take note that these provisions are mirrored in the Constitution Bail Guidelines for the Courts of Judicature, Practice Directions 2022, which again I will not reiterate here. I will go ahead to consider these factors so far as I find relevant. 1, the nature of the accusation. In agreement with counsel for the accused, the offense is not one of personal physical violence as to endanger other members of the community. It also has an aspect of freedom of speech, which in light of the presumption of innocence requires a balancing act. Here, court is invited to determine that if that right was used contrary to section 38(1)(d) to promote sectarianism. Here, in the criminal case, the court is invited to determine if that right was used contrary to section 38(1)(d) to promote sectarianism. And by that I mean freedom of speech. However, here we are not concerned with its proof yet. It's a bail application. So I agree that the consideration of bail, when such rights are in play, should be carefully weighed against the public risk. In this case, no such risk caused by the nature of the offense is cited. However, if bail is granted by this court, the accused would be cautioned to limit such utterances similar to those now in court and pending proof to avoid potential commission of other offenses during a period the matter is pending hearing. Gravity of the offense charged and severity of punishment. The offense charged involves the use of words, printed or uttered, or any act of hostility towards a group of people. The penalty is a maximum imprisonment of 5 years. This is not so grave as compared to the capital offenses, as I indeed noted the previous day. The prosecution did not dispute this, and the fact that it is covered under paragraph 13 of the bail guidelines and section 77 of the MCA, the prosecution did not dispute this, and it is also covered under paragraph 13 of the bail guidelines and section 77 of the MCA. As already noted, the only catch that I need to restate here is that the accused person should refrain from engaging in any further act similar to those complained of during the hearing of the matter. The third is antecedents of the applicant so far as they are known. Antecedents are important in a bail hearing. Indeed, as Masal Musoneje noted, it would be a mockery of the judicial process and a miscarriage of justice if bail is granted to a person who has a staggering record of previous convictions to his name. In the present application, it has been elaborated by counsel for the applicant that there are no previous convictions and the applicant intends to religiously attend court in this matter. Counsel set out the flowery record of service of the accused person and the distinguished offices she has held over the years to show her good conduct. Again, not much dispute arose from the prosecution. On the whole, the antecedents of the accused applicant have to be considered in her favor. 4. Whether the applicant has a fixed place of abode within the area of the court's jurisdiction. On the issue of the applicant having a fixed place of abode at Luzira Nakawa Division in the Kampala district, there was an objection from the state as regards the fact that the accused person admitted being in hiding and avoiding her home. Counsel for the applicant refuted such claims and reiterated that the accused's commitment to occupying her home. Without more, I find no reason to doubt that the accused person does not now consider her home her personal residence. If there was an insecurity, it would instead be up to the state to restore security so that the accused person is safe at her residence. It is no reason to deny her bail on that ground. 5. Whether the applicant is likely to interfere with any of the witnesses for the prosecution witnesses or evidence to be tendered in support of the charge. It has not been alleged that once granted bail, the applicant is likely to interfere with investigations, that's to say, witnesses or evidence. Counsel for the applicant submitted that there was no such likelihood due to the good previous conduct and responsible nature of the highly esteemed accused. If there are indeed grounds to lead to the opposite finding, the grounds would have to be clearly stated with evidence. This is in light of the presumption of innocence. And in the case of Panjo versus Republic that was cited, it was held that in such circumstances, the investigator should have a sworn affidavit to substantiate any such allegations. The judge too had this to say. If the courts are simply to act on allegations, fears, or suspicions, then the sky is the limit, and one can envisage no occasion when bail would be granted whenever such allegations are made. Thus, upon that ground, this court found that the accused person had met that consideration under that ground. Exceptional circumstances, advanced age. Both sides submitted on the issue of exceptional circumstances and advanced age. I agree with counsel for the applicant that it is not mandatory in this court to prove exceptional circumstances in order to qualify for bail. Under Section 77 of the MCA, exceptional circumstances are not required to be proved, as is done in the High Court under Section 16 of the TIA, being the Trial on Indictments Act, Chapter 25. However, even then, in the Magistrates Court, where such an exceptional circumstance such as advanced age exists, this is also a relevant factor to consider. In this case, it is undisputed as per the charge sheet that the accused person is 73 years, and thus indisputably falls within the ambit of a person of advanced age. For that again, you see that case cited of Dr. Alex Kamugisha versus Uganda as cited, where the court held that 50 years and above would be considered advanced age. Even with only such a consideration, it is unmistakably clear that the accused person would ordinarily be eligible for bail, for she meets the requirements set out in the MCA and the bail guidelines. I will, however, proceed to consider the alternative prayer as well, for this strengthens the position of the prosecution in ensuring that the objectives or general principles of bail stated in paragraph 5 of the bail guidelines are met. These principles include C, to ensure that the accused attends trial, and E, the need to balance rights of the applicant and interest of justice, just as the prosecution argued in their reply. For that reason, I will consider the status of the sureties presented to court. So on the sureties, I must emphasize, as Justice Musene did, that the duty of sureties is not merely to assist a friend or relative to get out of prison. The sureties have a duty to the court, which duty is to ensure that the accused or applicant does not abscond. In the event of an accused person absconding, the sureties must explain to court why the accused person failed to attend court. And where a surety has reasonable cause to believe that the accused is about to abscond, that surety should cause the arrest of the accused and have him brought to court. Otherwise, the sureties will be called upon to show cause why their recognizance should not be forfeited. As far as this case is concerned, I already set out the details of the 4 sureties of the accused person. I was enthralled by the high caliber of the sureties, who are no doubt substantial. The objection regarding their truthfulness was explained away. The phone numbers had been wrongly recorded. The fact that the accused person did not know exactly where the sureties stay does not automatically operate to reduce the substance attached to the surety. The fact that they have a fixed place of abode are traceable by their high offices they occupy, and several lawyers lead this court to consider them substantial enough. I was also satisfied that the sureties are persons who have understood their role under the law. This second angle on the bail application also succeeds. Politics. Before I take leave, I would like to comment on one final aspect of politics and its intersection with judicial work and the promotion of a peaceful coexistence in Uganda as a democracy. A case of promoting sectarianism has been preferred against the applicant, and she has intimated to this court that this matter allegedly has a political aspect to it. In light of this information, which this court has not verified, it nevertheless becomes prudent to caution all in authority and also pass a message to all concerned, including the applicant, now before this court, as follows. And for such a caution, you should also see the case of, you see what the late Justice Musene just said in the BCJ bail application that I have cited before. Uganda is a democracy. Democracy survives in a world of tolerance and forgiveness. I thus bring forth a message of reconciliation and hope and peaceful coexistence of all Ugandans. Uganda should be a free and safe society for all, with emphasis on peaceful resolution of conflicts and observance of the rule of law. The applicant is therefore called upon to live peacefully and not also cause any utterances similar to those currently charged, as long as the case against her is still pending in this court. I would like to emphasize, as I'm winding up, that courts of law are neutral arbiters and have no leanings or sides. It is extremely unfair for sympathizers of the accused person to, without more, bash a judicial officer, prosecution, or other court users for maintaining neutrality in handling a matter without any ill will, especially without proof. Likewise, it is also unfair for any person interested in the matter to advocate for the continued detention of a person to whom the right of bail would ordinarily be available. In the case of Colonel Retired Dr. Kizza Besigye versus Uganda, miscellaneous criminal application number 228 of 2005, again Justice Ogola, who was cited, stated that the courts of justice have the duty to jealously and courageously guard and defend the rights of its people. I am but a simple human being, entrusted with a noble and a heavy mandate to do justice to all in line with Article 126 of the Constitution of the Republic of Uganda. This is no mean feat. This is no mean feat. Judicial integrity does not always involve shunning bribes. Along with fighting corruption is also the requirement of a judicial officer to have a strong mind that is only swayed by the law and the relevant facts at hand. I owe allegiance to Uganda. I can only take a decision that I can live with a clear conscience. As a judicial officer with a Christian Catholic background, I'm fortified in the decision I'm about to deliver and pray that God shall be my judge. Having regard to all that the above circumstances, factors, and having judiciously and meticulously weighed one factor against the other, I'm inclined to grant the bail application on the following conditions. 1. The applicant is to be bound in her own recognizance of 3 million Uganda shillings, not cash. 2. Each of the 4 sureties is also bound in the sums of 2 million Uganda shillings, also not cash. 3. The applicant to execute a further bond of refraining from any acts of hostility or breach of peace till the case is heard and finalized, because failure to do so could lead to cancellation of bail. The applicant will continue reporting to this court for mention pending the completion of inquiries and or during the period of hearing of the matter, as the court will from time to time communicate. Since the power is back, I'll just print and sign and give you a copy. Yeah. So, on the file, I have noted that the ruling delivered in open court bail has been granted to accused person in the terms indicated in the ruling. As the matter is, as the inquiries are still ongoing, I will give a longer adjournment. So the matter is adjourned to 19th of August for mention. And if the allegations of the accused are also true, to get some peace of mind and rest. Court is adjourned. There is one case that I did not hear. I can hear it in chambers. One criminal case.